In the quiet where words can barely speak, he stands strong, never weak, not a lawyer, but he's brave to fight, turning truth into a quiet. He's a builder with no plans in sight, grafting dreams in the softest light. In the stillness where the world finds rest, Reggie dreams with the heart so blessed. He's the calm and the raging storm, a gentle power breaking the norm. With every step, every fight he's won, Reggie's alive before the dawn.
Greetings all. This installment of the VERI Community's dossier on the SEC review will go over ChatGPT's opinion of what is the most allegedly egregious actions. As a disclaimer and a disclosure and a statement, I am not admitting or denying any of the SEC's allegations. I'm not trying to relitigate the case. This actually is not about me or the Veritaseum companies at all. This is about the Veritaseum community and how this group of laypersons who are not U.S. attorneys, not members of the bar, simply members of the Veritaseum community have gotten together. They've done their own research, their own investigation, their own analysis, and laying the groundwork for what could potentially be true justice. So, with that out of the way, let's move forward. Below is a link to the full dossier, and also there's a link to a 4-page summary of the dossier. I strongly suggest everybody reads both of them. And let's ask ChatGPT what it thinks.
Based on the review of the dossier, here are the top 4 most damaging and potentially damning allegations made against the SEC by the VERI token holders, each backed by documented evidence or admissions within the dossier. 1. False representation of the Kraken account ownership. Allegation: the SEC, particularly Jorge Tenreiro, falsely claimed in court filings that the Kraken account was Reginald Middleton's personal account to support accusations of misappropriation of funds. In reality, the account belonged to Veritaseum LLC, a fact later admitted by the SEC's own expert witness, Patrick Doody, in his supplemental declaration. Supporting evidence: Doody admitted in his supplemental declaration that the account was in the name of Veritaseum LLC, not Middleton personally, after the initial misrepresentation was made to the court. Impact: this misrepresentation played a significant role in securing the asset freeze against Veritaseum and Middleton, directly undermining the fairness of the proceedings. Dossier reference, page 25, paragraph 13, page 26, paragraph 33. 2. SEC's misrepresentation of Veritaseum's platform functionality. Allegation: the SEC claimed in its filings that Veritaseum's platform was non-existent and not functional, despite attending a live demonstration where the VERI platform was shown to be operational. This misrepresentation was used to justify the emergency temporary restraining order, TRO, and asset freeze. Supporting evidence: the dossier shows that the SEC attended a live demonstration of the VERI platform on March 9, 2018, where the technology was praised by SEC staff. 4 days later, the SEC ordered the platform to be shut down, yet in court, they claimed that no such platform existed. Impact: this false claim directly undermined Veritaseum's defense and severely damaged the company's credibility. Dossier reference, page 16, paragraph 1, page 41, paragraph 1. 3. Coercion and manipulation of witnesses. Allegation: the dossier alleges that Jorge Tenreiro and the SEC attempted to coerce witnesses, particularly VERI token holders, into providing testimony against Reginald Middleton, even when those individuals insisted they were not defrauded.
So, Mr. Michael Middleton, could you please state your full legal name and current address for the record?
Yes, my current full legal name is Michael David Middleton. For the record, I want to say this is September 11th of 2024. And my current address is
Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do. I was contacted by the SEC through my attorney. I agreed to testify in this case to the truth of what I had experienced in dealing with you, Reggie, which we used Ether Delta, which was an exchange at the time that had a lot of volatility. And immediately after the transaction took place, we saw a huge decline in the value, and I expressed my concern in an email to you, Reggie. You immediately responded to me and corrected some of the assumptions that I had made in the email about how the investment was acquired and what you did and did not represent to me, because you had not given me investment advice. You told me very clearly that it was software, and I, being a software salesman, understood that well. As it turned out, you did offer to refund me the full purchase price, which I declined that offer and said, I'm just going to keep it because even though I didn't know fully what the Veritaseum was capable of in the future, I testified to that with the SEC. Number of questions came from your attorney, which I'm estimating was about 20 to 25 minutes, in which he asked all about the nature of the transaction between you and I, the emails, the verification of it all. When that was all said and done, and your attorney rested, and my attorney was there watching the whole proceedings, I believe the SEC asked me 2 questions, just 2. I can't remember what they were, but I answered them very quickly, and then the SEC shut it down. They didn't have any more questions, and I didn't know where it was going to go from there. I had my own personal life to deal with after that, and I kept, again, all the Veritaseum except for maybe 1 or 2, which I had purchased from you, Reggie. Some reports that you had made. One of them was about Populous, which you had, I think you remember. And I'd also had some other emails to you about wanting to see how else I could use the Veritaseum, either to purchase BSV or Bitcoin Cash, or to, I was interested in like silver and gold, like that you were doing at the time, or were getting ready to do with Veritaseum. I was also aware that you had negotiations with, I guess it was the Jamaican Stock Exchange, and those kind of things. At that point in time, I was unaware of any patents that had been granted or were pending, but I knew that you were working on stuff like that. So that kind of, in a nutshell, gives the overview of the testimony that I provided. I don't know, but I don't believe there was anyone else that testified, to my knowledge, other than myself.
Trey Cupp, a key figure, provided an affidavit outlining how Tenreiro tried to convince him that he was defrauded and pressured him to testify for the SEC. Supporting evidence. The dossier includes Trey Cupp's affidavit, in which he details these coercive attempts, showing clear pressure tactics used by SEC staff to manipulate witness testimony in line with their narrative.
What impressed me most about Reggie and his ideas were he didn't want to slant the needle one way or the other. He wanted to make a platform that created equal opportunity for everyone around the world through a decentralized platform. So I got involved in the platform, and I got to test the beta for the Veritaseum platform. I got involved very early in some of the things that Reggie was doing, and he was very successful. The code was really eloquent, and it did exactly what he said it was going to do. So fast forward to 2019, I got a telephone call from Jorge Tenreiro. So I decided to call him back. And when I called him back, he answered immediately. He gave me his personal line at the office. And we had about a 40-minute conversation. And I'm familiar. I'm an entrepreneur and a businessman. I've run several successful businesses, so I'm familiar with the way that prosecutors are supposed to go about their business. And they're really supposed to ask questions and not make statements. In other words, if you're a prosecutor and you have a suspicion that certain people are breaking the law, then you're supposed to ask questions of witnesses that lead to the conclusion that they are breaking the law. But Jorge took a very unusual stance, a very aggressive stance when he called me. There were several times during the conversation that he made very strong statements against Mr. Middleton.
Like, for example?
For example, there were several times during the conversation where he said, "You have been defrauded, and let me tell you why." And then he would go on and make the, case that I was defrauded. And so I got to the point where I just stopped him in his tracks on the defrauded thing. I said, "Listen, I'm not defrauded." I said, "First of all, I'm a businessman, and I signed a disclosure statement when I exchanged value for the Veritaseum tokens, stating that I knew that they were utility tokens, which gave me access to the Veritaseum platform." So getting back to the conversation with Jorge, he tried to get me to become a witness for the SEC. Again, at the very end of the conversation, he described the prosecution that they're going to unfold against Reggie, and he said that again he tried one more time. I think he tried 3 times to convince me that I'd been defrauded, and then he made a plea to me to be a witness for the SEC against Mr. Middleton. And I told him that I had no interest in being a witness against Mr. Middleton. I told him that I thought he was wasting taxpayer money and effort of a regulatory body going after somebody that was innocent of the charges that he was alleging.
And what did he say to you when you said that? What did he say?
Jorge was really aggressive, but I think he knew that he was beating his head against a brick wall. And so he really kind of tailed off at the end and said, "Okay, thank you for your time." He really didn't. He made one big last push during our phone call, and then it ended there.
Did they try to coerce others? And have you talked to them?
I've tried to find others that have talked to Jorge Tenreiro, but in my efforts, we have a Telegram channel with over 3,000 members, and I know a lot of the Veritaseum token holders, and I relayed my story of my interaction with Jorge to them, and none of them had the same interaction. From my understanding, there were a couple of hundred people that the SEC had telephone numbers for, but I'm the only one that I know of that actually had a long conversation with them.
Perhaps I can assist. Sorry,
go ahead, yeah.
Interrupting. Perhaps I can assist there because of the fact that I've been doing the complaint and the dossier. I've had the opportunity of communicating with at least 2, probably 3 now, potential witnesses, one of whom is extremely afraid to come forward because of the intimidating and aggressive tactics that were used against him during the course of the SEC's investigations. So I haven't pressed him for an actual affidavit as such. There's a couple of others that may well be prepared to step forward, but I'm sure there's many others that are just too afraid to step forward and speak their minds.
Why are they so fearful? Why did the SEC make them so fearful that they are afraid to talk?
I can answer that question. There's an individual that I won't name, but there's an individual that was supporting Reggie in the VERI platform that he put out there early on when we were doing beta testing. And the SEC contacted him and threatened him and his family with loss of their assets and prosecution if he continued making videos. So
if he continued making videos, so basically they were censoring him, telling him to shut his mouth.
100% they were
Otherwise,
censoring him.
Otherwise, we will destroy you. That's what the SEC
They
did.
basically threatened to destroy his life and his family's life. Yes.
And set the DOJ on him as well.
Wow.
Impact. Such coercive behavior could be considered witness tampering and raises significant ethical and legal concerns about the integrity of the SEC's investigation. Dossier reference page 2, paragraph 2, page 9, paragraph 10. 4. Failure to correct known errors regarding asset misappropriation. Allegation. Despite having knowledge that their expert witness, Patrick Doody, made critical errors in his initial declarations regarding the misappropriation of funds, the SEC did not correct these errors until they were exposed by Reginald Middleton's filings. Even then, the corrections were made only after substantial damage had already been done to Veritaseum's operations. Supporting evidence. Doody's initial declaration falsely claimed that Veritaseum's ETH was misappropriated to personal accounts, and later, Doody admitted that the Kraken account belonged to Veritaseum LLC, not Reginald Middleton personally. This correction was made after Middleton had filed comprehensive rebuttals. Impact. The SEC's failure to correct these known errors in a timely manner exacerbated the harm caused to Veritaseum and compounded the allegations of bad faith and misconduct in their investigation. Dossier reference, page 28, paragraph 33, page 32, paragraph 35. According to the dossier, Jorge Tenreiro did not correct the errors and false information admitted to by his expert witnesses in their declarations before submitting them to the court a second time. Specifically, Patrick Doody's declarations contained significant factual inaccuracies regarding the ownership of the Kraken account and the misrepresentation of Veritaseum's platform. Despite Doody's later admissions in his supplemental declaration that the Kraken account belonged to Veritaseum LLC, not Reginald Middleton personally, Tenreiro failed to correct these misrepresentations in subsequent court filings and continued to submit misleading information in support of the SEC's case. Legal and professional ramifications. 1. Legal ramifications. 18 U.S.C. Tariff 1001, false statements, failing to correct known false information in legal filings, could constitute a violation of this statute, which prohibits knowingly and willfully making false or misleading statements to the court. If Tenreiro knowingly submitted incorrect or uncorrected information after his expert witnesses acknowledged their errors, he could be criminally liable for making or perpetuating false statements. Potential penalty, up to 5 years of imprisonment, fines, or both. Fraud on the court. By knowingly submitting false or misleading information to secure favorable rulings, such as the TRO and asset freeze, Tenreiro could be seen as committing fraud on the court. Courts take fraud on the court seriously, as it undermines the integrity of the judicial system. Potential penalty. If the court determines that fraud on the court occurred, it could vacate the judgments that were based on the false information. This includes reversing the TRO and asset freeze against Veritaseum and possibly reopening the case. Additionally, Tenreiro could face civil sanctions or penalties. Federal Rule of Civil Procedure, FRCP 11. FRCP 11 requires that attorneys ensure that factual contentions in court filings have evidentiary support. Failing to correct false information admitted by expert witnesses would likely constitute a violation of FRCP 11, exposing Tenreiro to sanctions. Potential penalty. The court could impose monetary sanctions, issue fines, or other penalties against Tenreiro personally or against the SEC as a whole, depending on the severity of the violation. Perjury or suborning perjury. If Tenreiro knew that his expert witnesses' initial declarations contained false statements, but still allowed or encouraged their submission without correction, this could be viewed as suborning perjury. This would be especially true if the court relied on these declarations to make rulings that adversely affected the defense. Potential penalty. Suborning perjury carries significant penalties, including up to 5 years of imprisonment under federal law. 2. Professional ramifications. ABA Model Rule 3.3, Candor toward the Tribunal, attorneys are obligated to correct false statements of material fact previously made to the court. If Tenreiro failed to correct the errors in the expert witness declarations, he would be in violation of his duty of candor toward the tribunal. Potential consequences. Violations of this rule could lead to sanctions from the Bar Association, suspension, or even disbarment. In serious cases where false information materially affected the case, courts and bar associations impose significant penalties to maintain the integrity of the profession. ABA Model Rule 8.4, Misconduct. Failing to correct false information could be deemed professional misconduct under Rule 8.4, which prohibits lawyers from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Submitting false or misleading information to the court without correction would be a clear violation of this rule. Potential consequences. This could result in disciplinary actions ranging from reprimands to suspension or disbarment, depending on the severity of the violation and the harm caused to the judicial process. Obstruction of justice. By failing to correct misleading or false information in the case, Tenreiro may also face accusations of obstructing justice. Obstruction involves interfering with the proper administration of justice, which can include submitting false documents or allowing false statements to remain uncorrected. Potential penalty. Depending on the level of obstruction, penalties can range from fines to imprisonment and professional sanctions. Conclusion. If Jorge Tenreiro knowingly failed to correct the false information after his expert witnesses acknowledged their errors, he could face serious legal and professional consequences, including criminal charges under 18 U.S.C. 1001, sanctions under FRCP 11, accusations of fraud on the court, and possible disbarment for violating ethical rules. The failure to correct such critical information could result in a reversal of the rulings based on that information, reopening the case, and further legal scrutiny of the SEC's actions.
What you have seen and heard thus far is barely the tip of the iceberg. We haven't even scratched the surface yet. The Veritaseum community has put together a monumental compilation of facts, figures, and analysis. If proven true and accurate, or found to be true and accurate, should send ripples throughout the entire community. Not just the Veritaseum community, but crypto, securities, and regulatory enforcement in general, as well as the judicial arm. Now, let's take full advantage of this medium and hear from the token holder community themselves in a little, small, impromptu town hall meeting.
So what I said is, in this video, it's possible to realize that the amount of time during the moment the video was presented publicly or to the SEC representative, and the 4 days after this presentation, they struck back to you. They froze the company.
Yes, they made it clear that they did not want the product operating. And so in order to cooperate, I took the product offline.
Sure, but it's a very short time for a government agency to strike back. They are very quick. That's very surprising.
Yes.
And just prior to that, they were saying that the platform was non-existent. So how did they ask something that's non-existent to be shut down?
Good question.
They certainly had eyes on you before, otherwise it wouldn't be possible.
Apparently. Yes. What do you think of the potential legal ramifications, assuming the allegations prove to be evidentially made up a word, in case the allegations prove to be true? They are pretty significant in my opinion, but I want to hear yours. And remember, my goal is to educate everybody and not necessarily to say I did do it or I didn't do it, or I want to relitigate the case. I want the SEC's behavior to be apparent to everybody, which hopefully I should be able to do without recompense or consequences. We shall see. I probably shouldn't hold my breath on that, but my goal is to see what happens to the Veritaseum community at the hands of the SEC. So what do you think of the videos, the ChatGPT conversational analysis that I had in the video?
I find it quite disturbing myself to think that a government agency would be able to treat you that way. And in treating you that way, they affected us token holders. Well, not so much the token holders, but also by freezing your assets. We were affected because we were holding V assets and they were in amongst the frozen assets. I mean, I've got myself and family members who are seriously affected by that. And based on what I'm reading, it's quite disturbing to see how they've pulled that off.
I was wondering about the same thing with the well, the thing is too is that it seems, I think, contradictory to the purpose of the SEC, which is, I mean, I know you've spoken about how crypto is not a security, but either way, if the point of them is to try and protect investors from fraud and everything, it seems as they were the ones who caused the collapse of investors' assets.
Okay.
Exactly. Not protecting the retail investor. Protecting someone else.
I think that we're not interested in token holders or shareholders protection. It was purely like to protect other interests, and that is the reason why they did what they did in the fashion they did. Otherwise, it makes no sense.
Exactly.
Okay.
They were sent to stop the advancement of the platform from disrupting whoever stands to be disrupted.
I mean, especially if you see that the ideas have been implemented by other projects and used, maybe they are in favor, have some other big friends who protect them. For me, like all the technology and the project Reggie has been working on has been way advanced than other projects, and maybe it is to give other people a chance to, compete or get the market there is in the future.
Something like that. Protecting somebody. Certainly weren't protecting us, the V asset holders, token holders, or Reggie. Yeah, they wanted Reggie destroyed, out of the way. That's the way it appears.
Assuming this video would be seen or heard by the chair of the SEC, Gary Gensler, or by the senior trial counsel, Jorge Tenreiro, or the Congress members and senators who are in charge of oversight of the SEC, and or the Inspector General of the SEC, what message would this community want to convey, individually and together? Just speak up. They may very well hear you in this communication.
Well, right back when it happened, we asked for an explanation and for them to communicate with us. We did via a petition anyway, and via emails to them, and not a single response. So that kind of summed up where they were coming from. And yeah, we still want answers.
Okay.
we want the situation rectified.
Okay, and that would be aimed towards Gary Gensler, the chair, or Congress?
I would suggest start with Gary Gensler for sure.
Okay.
Let's be honest. Gary Gensler won't go against his own people. I think even if it's at the time where he wasn't the chairman. So I think the main people to address is the Congress. But that's just my opinion, you know, because they still work together at the SEC, and I can't believe that he's not in the know of what's going on there.
Okay. I do plan for this message to go considerably past the SEC. What would you have to say to senior trial counsel at the time, Jorge and his associates who worked on the case?
I would ask them who was giving them the orders. Why were they behaving the way they did?
Okay.
Well, specifically, I did not. I was under the impression that there were not very many outreaches, especially by if you go back to the investigation, the SEC witness, expert witness, Patrick Doody, he did not reach out to anyone. But I've recently found out that Jorge, the lead prosecutor in this case, Reggie, reached out to several token holders and used tactics that are not usually used by a prosecutor, thinking of what Trey said here. And apparently it wasn't just Trey that was reached out to. There were several token ICO purchasers that were reached out to by the investigative team. And I am just curious what was said there, because it seems we have at least an allegation of witness intimidation and coaching a witness, or wanting to coach a witness, basically against you, you know, and tell them what to say. The lead prosecutor was coaching a witness, and I just don't think that that's how it should be. I would also add that there was nobody that I'm aware of, no token holder, that reached out to the SEC claiming that they were defrauded by you. This was taken under, I am curious how it started. The commission has averred that they started investigating you when you announced that you were going to do an ICO in 2017. And then I would just also comment that it took 2 years before they filed a complaint. So there was definitely some, I have questions about the investigation, what was going on, because they were not reaching out to token holders, and token holders were not reaching out to them. So I'm just curious there.
Yeah, but you have to think about how many ICOs have been there at the time, why they choose who they chose, you know? That's, for me, it's very interesting why they choose Reggie and the ICO with VERI, like they say. There has to be something to that.
I agree.
Yes, I agree. Because look at because all you have to do is look at, you know, every other DeFi exchange, such as, you know, Uniswap and everything else, which is, you know, basically bits of the same technology. So it seems as why not go after them? Why only go after Veritaseum? It almost seems like they're deliberately going after the one who should rightfully have the most ownership of that technology.
Yeah, well, just on that point directly, Stephen Neroff, he's a crypto OG. He has opined that Reggie was targeted, and he used that word, and that is the word that I think we all are looking for, is the SEC targeted Reggie.
Well, one question, did they target him because they knew of the significance of his patents? You know, because fighting so many years to get that patent through, and have an allegation that he's like a fraud with the patent, and 1 year later he gets the patents. You know, it makes no sense. For me, they have to be working together, all together, to suppress